This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Trump administration is asking the Supreme Court to pause 4 cases so that the federal agencies involved can reassess the government's position in the cases, signaling the new administration will change the positions taken by the Biden administration. The cases involve a Biden regulation granting loan forgiveness for defrauded student borrowers, an EPA waiver to California, and 2 other cases involving Biden EPA regulations. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, is it fairly recent that a new administration comes in and changes the federal government's position before the Supreme Court?
There was a longstanding practice where the new administration would defend the legal positions of the prior administration. That has been jettisoned by both Democrats and Republicans in more recent years. And I think it makes some sense. Why waste the court's time to go over something when the administration may change position and moot out the whole controversy?
Here the administration is asking for a pause. Are they really asking for a pause, or since they're asking to stop all written briefing deadlines, does that put the cases on indefinite hold?
It puts the cases on indefinite hold. They're asking the court for that leeway in order for the agencies involved, in this case mostly the EPA, to reevaluate and change its position. And if the EPA does change the position in 3 of the 4 cases, that would moot out the current controversies that the court agreed to accept.
They want to review Biden's regulation granting loan forgiveness for defrauded student borrowers.
Yeah, so in this case, I think it's quite a sound policy, but it's one that the administration can change. The administration has set up certain kinds of regulations that say if a student can show that he or she was defrauded by the educational institution, then that creates a borrower defense, and the student need not pay back student loans. Obviously, this is controversial. It's controversial because President Trump was a defendant himself for the Trump University for some of these prior cases, but it's a relatively straightforward Department of Education policy. Nonetheless, the new Department of Education may want to reconsider and to change the regulations, and that therefore would, again, moot out the case, and the court need not waste its resources in deciding whether the Biden administration had the authority to create this borrower defense, which the Fifth Circuit had questioned. But certainly this has caused some concern for students who are deciding whether they have to pay back the loans from an education that they may not have actually received.
Another case centers on the Environmental Protection Agency's decision to grant California permission to set stronger climate rules for cars. So this is that sort of infamous California waiver?
Yeah, and the Trump administration actually limited that waiver during the last go-round, so it's not surprising that the administration will take another look at allowing California to impose these relatively stringent requirements on automobile manufacturers. Ironically, if you will, the case actually has to do with standing question about whether there is kind of redressability for a claim by industry analysis is that this rule will change the kind of composition of cars in terms of electric, hybrid, or gas-powered that will be marketed across the country. So the case doesn't really relate to this exemption for California at all. It has to do with whether fuel producers can challenge it. But nonetheless, what the Trump administration said was, we're thinking of limiting the waiver to California, so the entire challenge, including the redressability issue before the court, will be mooted out. And just to add, I mean, it may not be technically mooted out, but there's really no pressing need for the court to continue its analysis. It's probably alive as an Article 3 matter, but prudentially there's no reason for the court to hear the case.
I mean, why even say that they're just considering it? On his first day back in office, Trump said in an executive order that he was seeking the repeal of the new waiver granted to California in December. So it seems obvious where they are. Why are they pretending they're just going to look at it?
Because it hasn't happened yet. Once we get some senior administrators at EPA with some authority, I'm sure that the exemption will be, if not eliminated, at least scaled back for California. But that hasn't happened yet, and to allow at least the new officials to get into office and to make a binding order was a sort of a cautious, respectful approach for the administration to take.
The Trump administration also asked the Supreme Court to pause 2 other environmental cases. Tell us about them.
Those cases concern, in one case, whether there was a denial of an exemption for fuel companies to not comply with certain kinds of regulations for clean air. And in the other case, it has to do with the good neighbor policy that the EPA has established and a challenge to that. So in these cases, it has to do with actually venue where these cases can be heard. And the administration said, look, as a technical matter, venue issue is alive. It hasn't been resolved. But if we are going to change our EPA policy so radically, then the underlying lawsuits may not have any kind of oomph left to them. So you may want to save your resources, Supreme Court, and not hear the case.
In 3 of the cases, the court filings show that at least one party is objecting to halting the schedule. How does that play in? Is the court likely to grant what the administration wants?
I think the court is likely to, but in the past it hasn't always done that. There was a somewhat infamous case at the start of the Biden administration dealing with, again, an EPA matter where the court said, yes, it's unlikely that there's a continuing active controversy, but it may be resumed. So it's not dead from a Article 3 mootness context, and so it actually heard the case. So the court has the capacity to hear these cases despite what the Trump administration attorneys have requested. I think they're unlikely to because there is not such a need to clarify the underlying rules at this time or to even decide the venue issue, that the court is likely then to be respectful to the Trump position and get rid of these cases. They have the power to, so we'll have to wait and see.
And if the Supreme Court wants the cases to continue, the justices could appoint a lawyer to argue the Biden administration's position.
Yeah, no, the court has done that in the past. They've appointed amici curiae to really represent the interests of the former administration because the current administration is no longer defending the policy. And the court has done that for generations in a number of cases. They've done it more frequently in recent years. So it could happen. And so, for instance, to give you an example, maybe this question of venue about whether you can sue only in the D.C. circuit under statute is complicating individuals' lives in terms of where to sue. It's happened before. It may raise its head again in the future. And so the court says, look, we have a case. Let's resolve it now. And that would be a good reason why the court might then appoint someone to represent the Biden administration position on the venue question.
On Friday, the Justice Department actually reversed Biden administration position in one case over Louisiana's congressional map. But that won't have any effect on the case itself, right? Because it's not the Biden administration that's suing there.
No, in that case, it really had to do with an unusual situation where the Republican Louisiana administration was in favor of the new map, and yet it was challenged and held to be in violation of the Voting Rights Act. So it was a very unusual political alignment where the political leadership of Republicans thought that this was a safer way to comply with the Voting Rights Amendment, but obviously we'll have to see what happens.
These requests involve cases that haven't been argued yet. There are some argued cases that seem to shout out that the Trump administration would want to change positions. And one is the case over Tennessee's ban on gender-affirming medical care for transgender minors.
Yeah, the Squirmetti case is the one that comes to everybody's mind. And whether the court decided to take the petition that was filed by the Biden administration as opposed to the private parties is one for the ages. But it looks pretty clear that the Trump administration may well decide to go slow on gender-affirming care and not have the Supreme Court hear the challenge right now. But on the other hand, maybe they think they have the votes and they've pledged that they only want to have 2 sexes on passports, and maybe they decided they don't want to have gender-affirming care, and they may want the court to continue to hear the case. But that's a great example of where a change of administration may or may not result in the court jettisoning the case.
You know, if you go by the oral arguments, it seemed like Tennessee had the upper hand in the oral arguments. So maybe the Trump administration might want to just take a chance on that?
They might. And I think that they are in pretty good shape, not legally, but with the Supreme Court. And so they may make a calculation that this is actually furthering their mission to try to get the court to come down and say that it's within the state's rights to limit gender-affirming care.
There were also arguments over these ghost guns, which are largely untraceable firearms. And that involves a federal regulation. It's been argued, but that might be a case where the Trump administration changes position.
I think that's going to be a close case because the Biden administration had such a overwhelming case on statutory construction that the regulation could be salvaged. And it's just not clear to me that even the Trump administration is in favor of ghost guns. But as you point out, it's within the purview of the new administration to rescind the regulation. And so if they do rescind the regulation, then people can manufacture and sell ghost guns in their basements without any kind of identification and pass by all sorts of regulatory hurdles. And that's an extreme position, but it's one that the Trump administration might take.
And Biden did this too. He asked the Justice Department to freeze the battle over the border wall.
The Biden administration tried to do that with respect to some environmental cases as well. And I think it's respectful of the court to tell the court that this may no longer be a true controversy and that the court is better off using its limited resources in another area. So I think both administrations acted respectfully and by asking the court to pause, and we'll just have to see what the positions the Trump administration ultimately will take.
Yes, especially when the new Solicitor General is appointed. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up next on the Bloomberg Law Show, it's a tiny endangered fish that's become part of the culture wars. In fact, President Trump has even blamed it for California's wildfires. But Governor Gavin Newsom begs to differ. I'm June Grasso, and you're listening to Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Delta smelt is a 3-inch silvery blue fish that has somehow become a scapegoat, or perhaps a scape fish, for legal protections to save endangered species. And even stranger, President Trump blames the tiny fish for the devastating California wildfires, saying protections for the Delta smelt led to gaps in water access.
They talk about the Delta smelt, which is a fish that's this big, but it is really not, doesn't have to be protected because it's in other areas. It's in numerous other areas, so it doesn't have to be protected. The people of California have to be protected.
Trump even signed an executive order on day one targeting the Delta smelt, entitled Putting People Over Fish, Stopping Radical Environmentalism to Provide Water to Southern California. But Governor Gavin Newsom says that Trump has the facts all wrong and that state reservoirs in Southern California are completely full.
And somehow connecting the Delta smelt to this fire, which is inexcusable because it's inaccurate, also incomprehensible to anyone that understands water policy in the state.
Joining me is Caleb Scoville, a sociology professor at Tufts University, who's writing a book on the politics of the Delta smelt. So, Caleb, tell us a little about this little fish.
The Delta smelt is a small, translucent fish. It's about 2 or 3 inches long. It lives in the Sacramento-San Joaquin Delta, which is where California's major river systems converge, just east of the San Francisco Bay, where before the rivers kind of converge and flow out to the bay. It's a fish that only lives in that area. It's California's largest estuary, and it is also the center of California's water distribution system. So it's where giant pumps were installed in the mid-20th century to irrigate farmland in the Central Valley, California, San Joaquin Valley, and also provides water to major cities in Central and Southern California, as well as the Silicon Valley. So the fish is small, but it's a native fish that used to be one of the most abundant species in that ecosystem, and it has declined in recent decades because of the human transformations of its ecosystem.
When did it start to become controversial?
That's a complicated question. The species became considered for listing under the Endangered Species Act in the late 1980s and early 1990s. And at the time, it was somewhat controversial because regulators and stakeholders, agricultural interests, cities, understood that it may complicate the operation of California's water infrastructure. So it was controversial even before it was listed under the Endangered Species Act. But this controversy was mostly within the world of California water policy. So in the early 1990s, there were, concerns about what the effects of protecting this species would be. When it was listed under the Endangered Species Act, it continued to be controversial. But the listing of this species and also conflict over water quality standards between the federal government and the state government resulted actually in a lot of cooperation to avoid future lawsuits. And so the controversy sort of died down a little bit. And it really wasn't until the mid-2000s, the mid-aughts and late-aughts, that the controversy picked up again. And this was initially precipitated by a legal decision by a judge in California, actually a Republican-appointed judge, that the regulations protecting the species from those pumps that send water to farms and cities in California, the way that they were running the pumps was in violation of the Endangered Species Act. And so this resulted in a brief but dramatic shutoff of the pumps, and then an order that new regulations had to be put in place. This was 2007, 2008 that this unfolded.
Before that, was anything in particular done when it was put on the endangered species list to help preserve it?
Yeah, so when a species is listed under the Endangered Species Act, so any federal agency that has a project that's going to affect the species and could potentially cause harm to the species has to come up with basically a plan to avoid jeopardizing the continued existence of that species. So there were regulations that essentially regulated the amount of water that could be pumped at particular times. And then there were a series of other measures, including just various ways of managing water that were tried to, save the species from extinction. It's complicated. I mean, there were some habitat restoration projects. There was something called the environmental water account, which is essentially like setting aside a certain amount of water that could be used to pump into its habitat at certain periods of time. All of this is basically a way of managing water to try to balance the needs of ecosystems and the human interest in extracting water from its habitat. Now, I should mention that the Delta smelt is just one species among many that are affected by California's water distribution system. Salmon that are native to that area are also listed on the Endangered Species Act, as are sturgeon, and there's a whole complex ecosystem. So the Delta smelt, it's one species, but it's also a very sensitive species, so it's often treated as a kind of indicator species for the overall quality and health of the ecosystem. And these initial efforts, it was called the CalFed program, CALFED program, were intended to sort of balance the needs of the environment and people's interest in water, and as also as a way to provide stability to avoid future lawsuits that might shut down the system, because people were really interested in stability.
When the judge issued this order, how did it change what California was doing with its water systems, or did it?
It did require the agencies to rewrite the way that they were regulating the pumps and managing water in dams. I don't think it's fair to say that it completely reorganized the way water was used in the state. It's a very complex regulatory process that involves using the best available science to come up with a plan to avoid jeopardizing the continued existence of the species. So there was an initial shutdown of water for just a very short amount of time, days. And then there was a new regulatory regime that was put in place, and that was in place for many years. Overall, protections of the Delta smelt only account for a pretty small, pretty marginal amount of water that could have otherwise been used by people. But it was the dramatic shutoff that actually created a lot of headlines. And so really the controversy, even then, was fairly muted. And what made it a national controversy was actually not anything regulatory at all or anything legal. It was when Sean Hannity had an entire episode of his show on the Delta smelt, sort of blaming drought and Great Recession era hardships on the protections of the Delta smelt. So that was in 2009, actually more than a year after the decision that resulted in the brief shutoff of the pumps. So Hannity is actually the person who brought the Delta smelt into the national public sphere.
And why do you think this caught on as a controversy?
First of all, was the context. Barack Obama had just become president of the United States. There was also a recession, which was causing a lot of unemployment right after the financial crisis of 2008. California also, at that time, and it continues to be with Trump, just kind of an avatar for everything that is supposedly wrong with liberalism and environmentalism in the United States for certain subset of conservative commentators. So those aspects sort of align. And then the Delta smelt, being a very small and obscure species that is uncharismatic, it's 2 inches long, it has a funny name, it became a vessel for the implicit message that liberal environmentalists in cities care more about a small, uncharismatic species of fish than they care about hardworking, honest people like you. So there's a kind of implicit message, and sometimes very explicit message, that environmentalists simply don't care about their fellow Americans. And, that could also go for liberals, or could go for Obama, or could go for, in this case, Gavin Newsom. And, because the Delta smelt is a species that doesn't have an obvious use to people, isn't large or beautiful or charismatic, right? It's not the bald eagle, it's not even the salmon. It becomes a very useful symbol for everything that's supposedly wrong with environmentalism in America.
You wrote that the frequent usage of descriptors like tiny or little suggests that the Delta smelt's small size and lack of charisma made it the perfect icon to drum up right-wing resentment, allowing it to become a divisive cultural object. Yeah, I mean, it's a culture war's fish now.
Yeah, exactly. And so there's a very complex and interesting history of California water that the Delta smelt plays a role in. And the Delta smelt is regulated by the Endangered Species Act. It has accounted for some amount of water being set aside and not used by people over the years. That's true. However, this is a much smaller proportion than many critics would imagine. And also, those regulations that protect the Delta smelt also protect the quality of the water for people to use. Because of where the pumps are, there's only so much you can extract at a particular time, especially depending on hydrologic conditions. There's only so much you can extract without pulling in seawater, right? Becoming too salty to even use to irrigate crops or drink. So the idea, that you could just stop these regulations and take as much water as you want is not true at all. So the culture war thing, in 2009, I see that as kind of the moment where the Delta smelt escaped the world of California water politics. And I've done a systematic media analysis to show that there's no relationship between the hydrologic effects of protecting the species and when the controversy flares up. So really, the Delta smelt as culture war symbol or culture war object has very little to do with the world of California water.
President Trump has blamed protections for this fish for the devastating Palisades fire, that the gaps in water access were due to this Delta smelt.
Yes, he has. And let's be clear, that's completely false. There's zero truth to it, right? You can see why that connection would pop into his mind, because there are regulations of the species that do regulate how much water can be extracted from the Sacramento-San Joaquin Delta to California's water projects, which are the infrastructure system. So you can understand the connection, but it's very easy to refute what he said by looking at the reservoir levels in California and in Southern California in particular, most of which are at or above average for this time of year. There's plenty of water. So it's not a supply issue. If there was an issue with how much water we could take out of the Delta because of Endangered Species Act protections, it would be reflected in the reservoir levels. There were issues at the local level for the system that was designed to handle maybe a house fire, to be able to handle a city fire, right? And I'm not qualified to say what should have been done there. But the invocation of the Delta smelt is a complete misdirection. And it does nothing to help the situation. And in fact, it distracts from, the real tragedy and the real problems that we face in a climate change world, and also just in cities that face hazards that we need to manage.
So what's the status of the Delta smelt right now?
Yeah, the Delta smelt remains listed on the endangered species list. As experts working in the system, natural scientists working in the system would say it's arguably functionally extinct. So that doesn't mean that there are no Delta smelt left in the system, but there are very few. It is not what it used to be. There's now actually many more Delta smelt living in a captive population, sort of trying to maintain the species and do some experimental releases to try to potentially propagate it permanently in the Delta than there are in the wild. So it's actually a kind of a sad example of what we've done to ecosystems, but it's not as much of a factor in California water policy as it might seem, given how much we're talking about it.
And there are other protected fish in California.
There are other species protections like salmon, and you'll notice that the folks who will vilify the Delta smelt and regulations of the Delta smelt rarely mention salmon because they know that driving salmon to extinction is not a very politically popular project. So I think that says something about why the Delta smelt is such a useful strategic object for people who want to play kind of divisive culture war games against environmentalists or imagined environmentalists. But, there's a lot of other species that probably deserve our care just as much.
It's really a fascinating evolution of the Delta smelt into a culture wars issue. Thanks so much, Caleb. That's Caleb Scoville, a sociology professor at Tufts University. Coming up next, some unique lawsuits against the federal government over ICE raids. This is Bloomberg. More arrests in President Trump's crackdown on illegal migrants. ICE says there were nearly 1,200 arrests yesterday, and today federal agents conducted publicized arrests of undocumented migrants in New York City, with the new Homeland Security Secretary, Kristi Noem, on hand to watch. She posted a video saying, quote, "Dirtbags like this will continue to be removed from our streets." ICE has also touted arrests in Chicago, Baltimore, Buffalo, Atlanta, and San Francisco, saying the total of arrests since January 23rd is 3,552. In the meantime, some novel lawsuits have been filed over the Trump immigration enforcement actions. Chicago organizations that advocate for the National Sanctuary City movement have sued the federal government over its decision to conduct mass deportation raids in the city, saying that the policy violates their First Amendment rights. And a group of Quaker congregations from 4 states has sued the federal government over a recent policy reversal that allows immigration agents to conduct searches and arrests in so-called sensitive areas like churches and schools. They say the policy violates their First Amendment rights. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Chicago organizations are suing the federal government over its decision to conduct mass deportation raids in the city. Explain what the violation they claim is.
This is quite a creative lawsuit. I am dubious on its chances of success, but basically they are approaching it from this premise. They are saying that these Chicago organizations have a right to advocate for Chicago to be a sanctuary city, and that the Seventh Circuit, which is the Court of Appeals that governs the Chicago area, so it's the court right below the Supreme Court, has ruled that there's nothing that Chicago does that violates anything related to immigration law. And so, because these groups have a First Amendment right to advocate that Chicago maintain its sanctuary policies that don't violate immigration law, because of statements that the Trump administration and Trump administration officials have made against Chicago, saying that because they are so boisterous in their sanctuary city policies, they will be retaliated against with immigration enforcement, that this is not legitimate immigration enforcement. This is instead an attempt to thwart free speech, which could lead to the apprehension of perhaps U.S. citizens engaging in free speech or helping immigrants, etc. And so their requested relief is no more raids in Chicago. And so that's where I think the case goes a little bit off the rails, is that seems quite broad to fix this potential violation they're claiming might occur.
So this is novel. Have you ever heard this kind of an argument being made before?
I have seen a similar argument to this with regard to people in immigration detention, where they say, I've been retaliated against because I went on a hunger strike or I protested the conditions of my immigration detention, and hence my recourse for this should be that I don't get deported because I need to be able to pursue this claim that my First Amendment rights have been violated. And the courts have been very dubious and skeptical of these on an individual basis. So to think that they'll do it on a citywide basis and just ban, these types of enforcement actions in Chicago on this basis seems very unlikely. And it's also extremely unlikely because the case has been assigned to a judge that was appointed by President Trump. So if they thought that they were going to have a good chance, maybe because a different type of judge might be appointed. They didn't get the best of luck there. And so from that standpoint, I think a generally unlawful theory, they lead to even more lack of success given where it's been assigned.
I mean, I don't see how a city can stop lawful deportation raids by the federal government. I mean, the federal government has the right to make these raids, right?
No, correct. And this isn't even a city. This is organizations within a city saying that they want to continue having their free speech and that these raids harm their free speech because they're being done in retaliation for their free speech. I mean, look, it's worth a shot. It's a creative argument. It's interesting, but I don't think it's likely to be successful at the end of the day.
So the Trump administration is targeting, Chicago, also targeting New York. And there were raids, and the Secretary of Homeland Security went on these raids, and she posted about the raid.
Well, I think, look, they are trying to very much trigger to the public that immigration enforcement is a thing. It's happening. If you are here illegally, you need to be afraid of it. And so they're trying to get as much bang for the buck as they can, knowing that at the end of the day, they are running up against very soon a significant push-up against what's the current detention capacity. And so very soon, either they're going to have to release the very people they've just been arresting and create this sort of hamster wheel where they arrest people, they put it on TV, but then a couple of weeks later they get released because there's no facilities for them, or they're going to have to get congressional funding quite quickly to start ramping up the detention and removal capacity. But it's not going to be sustainable to do 1,000 arrests a day and then all of a sudden think that that's going to lead to an indefinite ability to do that without more detention space, without more immigration courts, etc.
I'm curious because apparently the New York Police Department told officers that its rules block them, because New York is a sanctuary city, its rules block them from participating in immigration enforcement actions conducted by ICE. But the mayor, Eric Adams, seemed to imply that this was being done in coordination with the NYPD.
Well, I think that what happens is immigration enforcement is in the eye of the beholder. And so if the NYPD is simply there to protect the ICE agents, so to speak, and is not actually interacting in any way with the actual people being apprehended who are the foreign nationals, then they can try to have it both ways and say they're not in any way, shape, or form engaging in immigration enforcement. They're there to protect the ICE agents. And I think that's what you're seeing there.
And another novel lawsuit about the raids. A collection of Quaker groups is suing the Trump administration over its policy that allows federal agents to arrest undocumented immigrants in houses of worship.
Yes, this is a outgrowth of the policy that was called the sensitive locations policy, where the sensitive locations policy was actually rescinded and says now that instead of not being able to go into places like schools and churches to create immigration actions, that there now can be ICE going into these churches and schools, etc. Now, here's the interesting thing about that. I don't think ICE has any intention of doing large-scale raids in schools or churches or anywhere else like that in any of those sensitive locations. But what they are trying to discourage, because this has happened this happened a few times during the Bush administration in 2007, is that people would run into a church when they saw ICE was coming. They'd get some notice and they'd see ICE coming and they'd run out of the back of their house and into a church. And then these standoffs would happen in these churches where the church would provide sanctuary for the person for months. And you'd see articles about this and you'd say, what is going on here? And so they're trying to avoid that by saying, look, that's not going to happen. We'll go in and we will grab that person if they expect to run into the church to do that. But, of course, now you're going to have this lawsuit, and we'll see how successful it is. I don't think it's likely to be successful, but the concept will be that they will say that this was a change that is, needed to be done by notice and comment vis-a-vis the Administrative Procedure Act, and you can't just make such an arbitrary and capricious change, and it's also violating the First Amendment freedom of religion because people now won't be allowed to worship in the way they want to because they're afraid that ICE is going to come and get them. And so we'll see. I mean, I will say this. The Supreme Court has been much more tolerant or favorable toward religious-based arguments than non-religious-based arguments. So to the extent that one is making a religious-based argument that your freedom of religion is being impinged upon, being able to go to church because now you're afraid that church is going to be a place where you're going to get snagged. I mean, it's interesting. I think the question is, where does that get narrowly tailored? And also, the courts don't like these sort of facial challenges without facts. I think what they would say is, look, if you come to us with a specific set of violations as applied, we may say, yes, as applied, these are violating the First Amendment and your free exercise of religion. But just telling us that immigration raids in general can happen in churches doesn't seem like this kind of facial challenge that the Supreme Court likes. So you have their aversion to facial challenges, plus you have their favorability toward religious challenges, plus you have the fact that a lot of people do like immigration enforcement in the Supreme Court, all clashing together. But my imagination would be that the immigration enforcement will prevail there until specific examples are given.
It makes more sense to me than the sanctuary cities case. At least it's got First Amendment and religion, whereas the sanctuary cities case, the argument seems really attenuated.
It's a little bit more of a challenge to win that case.
But as you said, both are challenging. Thanks so much, Leon. That's Leon Fresco, a partner at Holland Knight. And in other legal news today, a federal judge in Washington has temporarily blocked the Trump administration from enforcing a new directive to halt payments of federal grants, loans, and other assistance to an array of programs across the country. The order was in response to a lawsuit filed by a coalition of nonprofit organizations challenging the payment freeze. The suit claims that even a temporary halt in funding could immediately deprive people and communities of their life-saving services, including health care, small business support, and programs for the LGBTQ community. The judge will hold another hearing on February 3rd to consider whether to order a longer-term freeze. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.